Okay. Good afternoon. Welcome to the second lecture of this week, in which we are looking at the role of law in European economic integration. Yesterday, we looked at the three models of EU market integration through the lens of European law. Yeah? So these are legal models of market integration, not economic per se, not the stuff that Peter Rodenburg was talking to you about last week. Now we have our lawyers' hats on, and we are looking at the processes of economic integration through a legal lens. And we have yesterday looked in particular at these three models, and as they're shaped by EU legal rules, and we have paid attention to the distributive and redistributive consequences of these different models, and we have learned that there's always trade-offs between the different objectives, such as welfare institutions, sovereignty, democracy, that there's always trade-offs depending on which model you choose. Let's recap this very briefly, right? So we also looked at European integration through the framework of positive versus negative integration, and I mentioned to you that it sort of overlaps with the lens of the three legal models, but it gives you a different perspective on how different provisions of the treaty are actually structuring economic integration. So with positive and negative integration, yesterday we looked at legislative harmonization and the use of Article 114, and how that is an example of positive integration, positive in the sense that there is one standard set at EU level that applies to all member states, and through this kind of positive action at EU level, you create economies of scale in which there is no internal barriers to free movement. And negative integration refers to the set of treaty provisions which mostly contain prohibitions. They negatively, that's why we say negative integration, through prohibitions, by saying member states are not allowed to do certain things, or private actors, in the case of competition law, are not allowed to do certain things which would otherwise create obstacles to free movement. That is what we refer to as negative integration. And today, after a brief recap of the three models, we will look specifically at the free movement provisions, and we are going to look at the free movement of goods. Okay, once again, I think that is clear by now. Harmonization is sort of the federal standard. EU rule applies to all member states. The drawback of harmonization, start with the positive. The benefit of harmonization is that you create economies of scale, and that is often what actually big companies in the European Union prefer, because they operate across border. They want to deal with one legal framework instead of 26, 27 legal frameworks. So that is very strong on the economic benefits. It is weaker, or let's say the trade-off is that we have a union of 27 member states with very diverse socioeconomic, cultural, historical conditions. And one standard for all doesn't always work well. So in terms of diversity, there is a trade-off with harmonization. Some would argue there's potentially also a trade-off with democratic legitimacy, because those people who would argue that the EU institutions suffer from a democratic legitimacy deficit would say, well, then they would also not support harmonization to be the dominant model in the EU internal market. But as we saw yesterday, that argument needs it needs some nuance, it needs good reasoning, and you should, whenever you claim that the EU suffers from a democratic deficit, you should be able to substantiate that claim and to actually explain what you mean by that exactly. It's not as straightforward as you would think. Then we spoke about the host country model, and that is the typical model that applies to international trade. Yeah, so it is the state to which the product or the economic activity comes, the state where companies bring things to the market, that is the host state, and the host state has the right to regulate its market and the activities taking place on its market. So that is a rule established in international trade. And the only safeguard against protectionism is the principle of non-discrimination. Now, we have also seen yesterday that potentially in some areas we still have that model in the EU internal market, but over time, as European economic integration has deepened, we realize that this might not be enough for deep economic integration, and that the trade-off here really is that it still creates too many obstacles to free movement of goods and the other freedoms. So the trade-off here is you can't really create economies of scale and deeper economic integration with this model. And then we looked at the home country model, which is sort of the reverse, right? It's not the country whose market, it's not the country on whose market the economic activity arrives. It is rather the country of production where the product, let's say, if we stick with the free movement of goods, it's the country of production where the product was produced that has the claim that its rules will be recognized even in the country of sale. So it's the country of origin principle, and we are going to look at this in more depth today because over time, in negative integration with free movement of goods, this has become the dominant model. And it has become the dominant model thanks to some interpretative choices on the part of the highest EU courts, so the Court of Justice above all. This model scores relatively well on the economic benefits. It requires a lot of trust among member states that countries which, let's say, have to admit foreign products on their markets, and by foreign here I mean EU foreign, not external of the EU. But let's say if the Germans accept that, to take my cheese example, the French cheese on their market, they have to sort of trust that the French know what they're doing when they're allowing cheese to be produced with unpasteurized raw milk, and that this will not create a hazard for health, for human health, for example. So it requires a lot of trust, but it was assumed as economic integration went on that we have reached a level of integration in which we have quite a lot of trust in each other meaning that member states and their societies have a lot of trust towards the levels of protection in other countries, although that is not always the case, of course. But the presumption is that we have a level of integration politically, culturally, and economically that allows us to put trust in each other's regulatory systems. And so today we want to look at, as I said, we are in the realm of negative integration, we're in the realm of free movement rules, and now we look back at Article 26, which defines the internal market as an area without frontiers, which consists of the free movement of these four elements: goods, services, persons, and capital. Now, if you go deeper and if you continue with EU law, you will learn gradually more and more about each of these four freedoms, which are sort of the core of the, sometimes it's referred to as the EU's economic constitution. It's sort of the foundation of EU economic integration, and it consists as you will see in these kind of factors of production, persons, capital, and goods and services. Okay. Now, in this lecture, the idea is only to introduce you to the ways in which law shapes economic integration, and therefore we will focus on the first of these four freedoms, on the freedom of goods. And that is not only for reasons of simplicity and not having the time to cover all four freedoms. It's also because freedom of goods is actually the foundation of the EU as we have it today. And it's funny to say this because a lot of these cases are actually about, what are they mostly about? What do you think? What the case law of the European Court of Justice, if you look at freedom of goods, what kind of stuff do you find there mostly? What are the procedures mostly about? Or the litigation, mostly companies bringing national measures to court because of infringement of treaty rules on free movement of goods, and it's mostly about, what do Europeans care a lot about? Money. Okay, yes, they do. But that's not what I mean. What else do we care about? Think about goods, yeah? Farmers, and here we are already closer. So we care about food and drink. Yeah, here in Europe we care a lot about food and drink, a lot of diverse cultures, a lot of local traditions, and most of the case law on the free movement of goods is actually built around litigation, about food and drink. So that's also going to be the case, but the case in our examples today. But originally, actually, you could also say that the European integration started with free movement of goods. It started with the European coal and steel community. So coal and steel, yeah, as the goods that were chosen as the first ones that needed to be, where we needed more economic integration, of course, because after the Second World War, the goal was, now if we integrate on these goods, if we integrate these parts of our economy, we can prevent war. Yeah, so that was the beginning, making war in Europe impossible. And it didn't quite work out this way, but at least within the EU so far. Okay. So freedom of goods was the first avant-garde area to try economic integration and to replace borders and duties and customs and tariffs with rules on how free movement of goods could be organized. Now, but interestingly, you think food and drink is boring, but actually food and drink is quite fascinating because, we humans, you can say sometimes, you know this saying, we are what we eat, right? Basically says something about the importance of food, for example, in our culture and even in our political systems. And you also refer to the farmers. And of course, food is also deeply, deeply related to questions of environmental protection and social justice and all of this, and public health. What kind of foods are we exposed to? What does it do to our health? All of these questions, they're actually quite political, deeply political topic, food and drink. And so the idea behind this kind of integration through free movement of goods is also that if you integrate these areas of national economies, you also will create spillover effects. Spillover effects means that if you start integrating one thing, you'll have to integrate other things as well. You eventually, European societies will grow closer together. And perhaps you remember that initially, at the beginning of European integration, so around the time of the Rome Treaty, we actually had other treaties, the European Defense Treaty, for example, and the Political Union. So the so-called founders of the community have attempted to integrate politically first, and in terms of their defense industries, but it didn't work out because of national opposition. So the French famously voted against the defense treaty in a national referendum and stopped that. So political integration was actually the first idea of the founding members of the community, but it didn't work out politically. The societies were not ready for that. But what then worked was this path of economic integration with potential spillovers over time to other areas. And we have seen that this has indeed been the case, although not without challenges. So, let's look at a couple of examples. And let's start with pasta. And let's think a little bit about these things, that it's a product, it's food, but it's also much more than that, right? So the cultural, political implications of food. Let's think about that. Here on the picture, you see a package of Italian pasta. It says made in Italy. Is this package, the fact that it says made in Italy, is that an obstacle to free movement of goods? And we'll go more into the legal nitty-gritty later, but for now, let's keep a bit of a more general mindset. If you are working for the European Commission and you get a complaint that the Italians started packaging their pasta and writing made in Italy on it, and you are an internal market expert, a free movement of goods expert, and you have to analyze a bit. Is this a problem from the point of view of free movement of goods?
Yeah, because it could be considered that you're discriminating a product. So if there is like some pastas like say made in Italy and you're Italian, you maybe gonna prefer ours buying your own product instead of buying other European products. So maybe you're giving an advantage if you do so.
Yeah, so you're saying it kind of works on the level of behavior, influencing behavior of the consumers, and it may be an advantage if people prefer Italian pasta. Why would they prefer Italian pasta? Because the Italians think their pasta is the best. Okay, so, but is this a direct discrimination? Is it discriminating against foreign products on the basis of their nationality? So when we say discrimination or direct discrimination, this means that a member state, in this case Italy, would do something that would sort of target foreign products like German pasta, for example, and would say, well, these we treat differently than our own products. That would be discrimination based on the origin of the product, based on its nationality. Is this a direct discrimination? You say yes?
Yeah.
Can you explain?
If you're undermining the reputation, I guess, of the product from another country because of the where it comes from, then it's not fair.
You are undermining other products by emphasizing that this product is made in Italy.
No, not in that way.
In which way?
You were saying that I do it, that undermining some product from another country. Yes, but in this case...
No, just look at this case. Just
in that case, no, it's not.
here it's not a direct discrimination. Why not?
Because made in Italy, someone prefers made in Italy rather than made in
Yeah.
some other country,
Yeah.
they should be free to choose.
It doesn't say buy Italian pasta only. It doesn't say don't buy German pasta. But it says made in Italy. It means something, right? Who would like to defend the position that this is legitimate and that the Italians should be allowed to do that without there being an infringement of free movement of goods under EU law? Yeah. I mean, the French also put their names on champagne is only allowed to be called champagne if it comes from that region. And, Europe, Parmigiano is only called Parmigiano because there's plenty of this kind of labels of origin on European products. And you say, but if you think about why they exist, what is the broader societal goal, or perhaps a public good, behind this kind of labeling? I mean, if you could say, okay, this is just commercials, they just want to sell more, but behind that there's something else, no? Could there be a legitimate goal that is protected here? What is being spread to other countries? Your culture? Mm-hmm. Yes, there is a sense of cultural pride. Pride about what? What are they proud about? The Italians and their pasta. Well, there is a, yeah?
Well, I guess how they make the product, how they produce it.
Yeah.
Quality.
Yeah, quality. There is a quality claim behind that, of course. There is a long-standing tradition in a particular region, maybe centuries, centuries of tradition of how to do this particular product. There's a lot of know-how. There is a claim that this is the best way to do this, and we don't want this to be, now if I'm not Italian, but I'm assuming the role now. So if, as an Italian pasta producer, maybe a local producer, maybe you're even a small producer, you're saying, we have done this, we have invested so much into this because it is what makes our product so good. We want it to be recognized. So it's difficult to make a straightforward judgment here about whether or not this should be running against EU law and whether EU law should prohibit or allow these kind of things. Now, it is a borderline case. So, in fact, the situation that has triggered some questions about EU law compatibility was not so much made in Italy label, but it was more that Italian pasta, the Italian laws prescribe that pasta has to have a list of ingredients, and the ingredients that are produced in Italy have to be indicated as being Italian ingredients, because for pasta, apparently, I think it's important that there is grano duro, how do you call that? Something with grano duro and something about Italian origin there.
It's also another reason why made in Italy makes sense, because most other countries don't produce with grano duro.
Yeah. So something about grano duro, that is a claim of quality there, and so it was something like that. Okay. So what is at stake here is always a question that we have to ask ourselves. What is at stake behind these labels and behind these questions? And then sort of in the analysis of EU free movement law, these kind of claims of quality, of perhaps consumer protection, or other public goals have to be taken into account. We'll come back to that. By the way, interestingly, today we again have actually a new development at EU level, where the EU now, in this whole dilemma about European competitiveness and geopolitical troubles, is developing an idea that they want to have a Made in Europe label at EU level, so which is somewhat ironic given how EU law frowns upon made in Italy or other sorts of local production labels. Okay, this is just a note aside. What about beer? So who is a German beer lover and who prefers Irish beer? Okay, so the Germans are very proud of their beer tradition. And they have these very old laws in place which are called beer purity laws. Yeah, so a bit similar story like with pasta. That's the way Germans have been brewing their beer for centuries, and they want to keep doing it this way, and they want to put they linked a certain claim to quality here. And then maybe they also want to say that beer that is not pure, in the German sense, should not be marketed or allowed as beer on the German market. Maybe they would even say Guinness is not a beer according to our standards. Is that okay? I mean, pasta has some health benefits, potentially. Beer? Are we more skeptical about alcohol here? Should we allow Germany to claim its purity standards and potentially restrict Guinness on the German market? Should Germans be allowed to ban Guinness on the market, at least when it's claiming to be beer? No. No. You're tolerant.
I mean,
yeah.
It would be to harmonize it and just discuss what is beer in the European level, because it's not like gonna be the same thing with chocolate, that they had the whole discussion of what is chocolate, and I think it's just be clear to the consumer that this beer is not a German beer.
Right. Yeah, so you're arguing in favor of maintaining diversity. We can accept that we have different ideas about what good beer is. We can live with that. We can allow these things to be sold on our markets. Consumers will know which beer they prefer. Okay. But again, this is somewhat a borderline case if you think about the range of options that Germany would have. So it could restrict Guinness, but it can also do other things, like it can require labeling. Again, it could require some type of label that says, well, this beer is not brewed according to our German purity laws. And that would again be a bit more difficult to assess, perhaps, because you would have again to weigh these claims of local culture and quality and tradition against economic freedoms and the free movement of goods. Okay, so these are just some examples to warm up and to alert you to the multidimensional, to the multiple dimensions of free movement of goods. Goods are goods, but they have environmental implications, they have health implications, consumer protection, quality, diversity, local culture, history, all of these things play a role. What we are going to look at today, as I said, free movement of goods, and more specifically, I want to go through two dimensions of free movement of goods. The external dimension, customs union, we will talk about this very briefly. And then the internal dimension, which is where where there's a lot of legal developments that we need to talk about. The customs union. Why am I saying external dimension? Well, because the customs union, the idea is that in a customs union, you've learned about that already last week. A customs union is basically one economic space with one common border at which tariffs are imposed on everything that comes in, right? So internally, there is no customs, there's no tariffs. All internal customs between member states are prohibited and have, in fact, already been abolished since the end of the 60s. So it is not a problem anymore in terms of legal questions. They're prohibited, they have been abolished among member states. Now, we do have today, again, an increasing focus on the question of tariffs externally. And of course, you know that, you've heard all about it. Whenever now Trump is threatening new tariffs because he wants Greenland, or for some other questions that he wants to create some leverage. It's the European Commission and Ursula von der Leyen, the President of the European Commission, that will negotiate with the US government. So it is in this policy area the EU has exclusive competences, and it's the Commission who takes the lead and will settle all kind of questions around tariffs between the EU and other states. So common external customs have become very prominent, but this is the realm of international trade law, and we are not going to go into that. The second element of the customs union, next to a common tariff at the external border of the customs union, is the common commercial policy. And that is the policy that governs trade relations between the EU as a trading bloc and as a customs union with other countries and trading blocs. So one very recent example, one that I think we'll also be discussing next week with Matteo Vermeglia, is the EU-Mercosur trade agreement, right? That, again, this is something where you will usually see the Commission President Ursula von der Leyen shaking hands and signing the agreements, because it is the Commission who has the exclusive competence to negotiate and conclude EU free trade agreements. Now, you may have heard that there's been a lot of trouble around the EU-Mercosur. Have you followed the news? Have you seen what happened after the EU-Mercosur deal was signed by the heads of states of all the participating countries, including the EU? That was just after, it was after Trump said, I want Greenland and I will impose tariffs on you. And then it was just before the Davos World Forum that the EU all of a sudden, after years and years of negotiation, has managed to sign the EU-Mercosur trade agreement. And what happened right after that? Has anyone picked up on that? Yeah?
They had a vote on it in the European Parliament.
Yeah.
Like a lot of people, both the ideological fractions within the Parliament and certain nations, as like a whole, have voted to send it for judicial review.
Right, very good. Indeed, the European Parliament voted, as the European Parliament is involved in procedures on EU trade agreements, and it voted that it was signed already by the Commission, but the Parliament had a vote that it has to go to the European Court of Justice, because the Parliament has doubts whether the EU trade agreement is in compliance with the EU, with EU law in general, but specifically also with EU environmental rules. Okay, and now the trade agreement is signed, but we are waiting for the legal opinion of the European Court of Justice, and that might bring new complications for the EU common commercial policy. Okay, but in these matters, so customs and common commercial policy, typically it is an area where the EU speaks with one voice, as one country. That sometimes creates some confusion in people, I think, because people often think, well, here they act as one voice and one country, but then when it comes to other questions around Ukraine or other foreign policy questions, all of a sudden they get nothing done, and they're not one country, but they're 27 different countries, and there's vetoes, and there's all these things. Well, that has to do with the fact that the EU as a legal entity is fragmented. In some areas, the EU has exclusive competences, and it doesn't need the agreement of member states, such as in common commercial policy. But in other areas, such as foreign policy or defense policy, there is no such thing as an exclusive competence. EU competences are very weak, and it's the member states who are in the lead. And there, the EU looks way more as an international organization and less as a unitary state actor or federal state. So the EU, therefore, is a very strange animal in terms of its constitutional setup and its identity as a legal global actor. And for some people, this is quite confusing because they find that the EU is either too weak or too strong, depending on where you look at. Okay, good. So we will go into the break in a moment, and after the break we'll go into some legal questions. But for now, this is an overview of, so I just spoke about the external dimension. Now this is the internal dimension of free movement of goods. There's a number of provisions in the treaty that are relevant for the free movement of goods. We generally distinguish between tariff barriers, so-called fiscal rules, and non-tariff barriers. Fiscal rules are basically, custom duties, another word for tariffs, and everything that looks like a tariff. There's also a provision, Article 110, that prohibits discriminatory internal taxation, which is another way for member states to discriminate against foreign products. However, the most practically relevant, legally vibrant area of EU free movement rules is the area of non-tariff barriers. And non-tariff barriers is another word for any national regulation that has an effect on economic activity. And in fact, over the last 30 to 50 years, in international trade more generally, not just within the EU, the bone of contention has not been tariffs. We're returning back to tariffs. But for a long time, tariffs, there was an agreement that tariffs, there were agreements on tariffs were low, there was an agreement that that's good for international trade, and that we want to keep that. What was problematic always was the question of so-called regulatory barriers to trade. And those are not measures that are imposed on products when they cross borders, so at the border, but those are internal measures that states adopt for a variety of reasons. Could be consumer protection, environmental protection, transparency rules, labeling, all sorts of things that states may do to regulate their economies. They're measures to regulate markets. And member states assume that they have the right to regulate their markets. But at the same time, for international trade, different regulations create obstacles because companies and economic actors have to comply with, every time, have to comply with a new set of regulations and rules. And that creates costs, and that is something that companies operating across borders don't like. So the biggest problem, therefore, for both international trade, but in our case specifically for European economic integration, have been regulatory barriers to trade or regulatory obstacles, just national regulations and the fact that they're different from state to state, like the rules on beer and pasta, yeah? And this is what I want to focus on in the second part of the lecture and look at a couple of cases that we will then try to analyze through the lens of the treaty provisions. Now we can take a break, and I'll see you back at 2. Okay. Let's continue. All right, so I told you that I'd like to focus with you on the non-tariff barriers, on the regulatory barriers to free movement of goods. And in particular, we will look at Articles 34 to 36 of the TFEU, which prohibit both quotas on imports and exports of goods and so-called measures having equivalent effect. Now, as a teacher of EU law, I have the pleasure to explain to students what measures having equivalent effect to quantitative restrictions are, which is a mouthful. What I want to tell you before we go into that is that this technical thing that you find in Article 34 and 35, that expression, this legal term, has actually had tremendous consequences and impact on European integration. Because it is that, and that is generally how sort of law works, and the power of law in the world is that sometimes with very technical words and the way they are interpreted and applied, all of a sudden you can achieve a lot of impact on the world. So we're going to look at what this legal term has done when it was used by litigants and by courts. And I will even claim that to some extent it is the interpretation and the use of this legal technical term that has potentially contributed to things like Brexit. That has, on the one hand, the use of these provisions and of these technical terms has created more and more economic integration. At the same time, it has also created a lot of backlash. And again, processes of disintegration, the most extreme example of that being Brexit. Okay, but now we are already thinking as lawyers here, and of course the first question before we move into any application of free movement rules is to actually have a legal definition of what a good is. Because if you're not dealing with a good, then you are outside of the scope of free movement of goods. So the first question on your mind, whenever you're confronted with a factual scenario that involves some economic cross-border activity, you have to ask yourselves, well, is this actually, is a good moving or not? And do free movement of goods rules apply at all? So a legal definition of a good has been provided by the court. Often the treaties do not contain all these definitions, but it's judges who then have to develop them. And the Court of Justice has defined a good in the meaning of free movement of goods, so Articles 34, 35, 36 of the TFEU has defined it very broadly. So all products which can be valued in money and which are capable of forming the subject of commercial transactions. So this is very broad. Basically, the only question that matters is there a market for this? And you know that we live also in a highly, well, in societies where the economic thinking is quite dominant, so basically everything can be commercialized as a product, right? So even things that we usually don't tend to think about as products, such as, for instance, romantic relations or something like that, if you look at dating apps, yeah? But so the only question is there a market? Furthermore, free movement of goods applies to all goods that originate in the EU or that have come from outside the EU but have cleared the customs. So let's say a Chinese solar panel arrives in Rotterdam, clears customs, and then enters the intra-European market and travels further to Germany, its final destination, yeah? Between the Netherlands and Germany, it benefits from free movement of goods because the moment a foreign product clears custom in the EU, it is treated as a good under the protection of free movement law. So either it's an EU product or it is a foreign product that has cleared custom. The nationality of the trader is irrelevant, right? Doesn't matter who is ultimately selling it. Let's go through a couple of examples. Is garbage a good that benefits from protection of free movement?
Someone wants to buy it, definitely.
Voila. If there is a buyer, there's a market, and it's a good indeed. And of course, we know that in a circular economy where we recycle things, there are companies that actually make their living from garbage, right? They collect garbage, they process garbage, and so on. So garbage is a product. What about electricity? And I don't know where this image comes from, to be honest. A colleague of mine that I took the slides over has put this, but I don't know what this image means exactly. Electricity is on your side, but okay, let's think about electricity. So you have a bill that you pay every month for electricity. Are you paying for a good or are you paying for a service? When you pay for your electricity bill, are you paying for a good or for a service? Service. Explain.
I just went on intuition.
Try following your intuition with some reasoning. Nothing wrong with intuition, but also some reasons. Why do you think it is a service? It's not wrong.
Could you repeat the question for me again?
Yeah. Why is electricity a service? When you pay your electricity bill, why are you paying for a service and not a product? Your intuition is not wrong.
Is it because it's
Trust it.
Repeated action, something?
It's repeated. Okay, maybe we're getting warmer. Not exactly, but think further. So what happens for your electricity to arrive at your place?
Has to go through certain places.
Yeah, somebody has to do something maybe to deliver it to you. There must be some infrastructure in place which channels the electricity to your house. So there's some services involved in that. But there's also a good... Yeah, you wanted to say something?
Yeah, I guess it's a good because what I pay for is the electricity which then powers what I need to use.
Yeah, so you're actually paying for a unit of electricity that is a physical product, but the way you get it, the only way for you to get it is if it's combined with the provision of services. People who build the infrastructure and do whatever is necessary to be done for you, the electricity to arrive to your place. So you pay for both. The correct answer is you pay for both, but importantly, electricity as such is a good that requires further services to be delivered, but it is a good even if we cannot per se touch it. Yeah, so even intangible things can be goods. And often you have to distinguish between services and goods because different provisions apply to services than to goods under EU law. And the way to distinguish between goods and services is exactly to think about a product as something that, well, maybe the other way it's easier. A service is actually an activity that you pay for, whereas a product is a thing that you pay for. So activity that is due, that somebody promises to do for you, and you pay for the completion of that activity and not for the thing itself. Okay. What about drugs? Like marijuana? Thing, a good, well, is it a good in the sense of free movement? It's a thing that you can buy. There's a market for it. Does it benefit from the protection of free movement goods? Free movement of goods.
No.
Why not?
This is a special case where
Oh, there.
it's regulated differently from the other products.
It's a special case. It's regulated differently. And what's behind that?
Because it's of the latitude of every state, the one per hour.
I'm looking for, you're close, you're close. There is something that makes it different. What makes a drug different from a range of other products and goods that we can buy? Do you have a right to buy a drug in the same way that you have a right to be able to buy your groceries? I mean, maybe in some medical cases it gets too complicated. But yes, what did you want to say? Yes, yes, yes. So the distinction is really between legal and illegal things. Yeah, and yes, illegal goods, they don't benefit from the protection of free movement of goods. Okay, so that's an exception. That's an exception, yeah. Okay, the legal provisions that we want to look at are these. Article 34, 36, I already mentioned them. And there is a provision on imports and on exports, and 36 is an additional provision that tells us when national restrictions on free movement of goods can actually be justified. Because, and that is very important for legal reasoning, you can have rules. Member states can break them. Well, rules on free movement in this case. Member states can break them sometimes if they have a good reason for it. And so whenever we look at the legal analysis of these provisions, we look at, do they apply? Are the conditions fulfilled? Is this really a case of prohibition? Is this national measure really prohibited? And once we have the finding, we conclude, yes, it is prohibited, and the member state violates this treaty provision, we still have to ask a last question. And the last question is, okay, so there is a violation of free movement rules, but could it be justified? And that is regulated in Article 36. So we will focus on imports. Article 34, restrictions on exports are a bit more rare. They don't happen as often, whereas imports suffer more from all sorts of restrictive national measures. Article 34 and 35, they also mirror each other in terms of the language. So Article 34 says quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. The first question you ask yourselves is, well, as we said, are we dealing with goods? Okay, if we're dealing with goods, are we dealing with trade between member states? That is called the so-called interstate element. And EU law does not apply if there is no interstate element. Why does EU law not apply to situations in which we don't actually have cross-border economic activities? Let's say situations which are only happening within one member state without any links to other states. Why doesn't EU law apply if it's not cross-border trade? Because that would restrict the right to regulate of member states, because member states still have jurisdiction over their internal matters, and they have only delegated powers to the EU to regulate cross-border economic activities. Otherwise, EU law and European institutions would intervene in any national affair, whereas it was created as an organization that is supposed only to regulate and solve cross-border problems. So the cross-border element is a precondition for any rule of EU law, or in any case of EU internal market law, to apply, and you have always to keep it in mind when you're confronted with with a situation and you have to analyze it. So cross-border element is the first question. And then you have to, there are two options. So we have quantitative restrictions and we have measures having equivalent effect. Now, quantitative restrictions is easy. These are quotas. So if the French decide that they only want to let in a certain amount of tomatoes from Spain per year because they want to protect their own farmers from the influx of Spanish tomatoes, that is a quota and that is prohibited. So total bans or partial restrictions on imports or exports are prohibited. These kind of quotas are still taking place more often in international trade relations, but they're less common within the EU. So we move on. As I said, the problem is here. The problem is with measures having equivalent effect, because what does it actually mean? So when we're not talking about quotas, we're not talking about tariffs or import duties, we're talking about something else. What is left? There is no definition in the treaty, and so again, this is subject to case law and to the interpretation of the European Court of Justice. Now, we could think, and originally that's what people thought at the beginning of European integration, that we're talking about discrimination. So what Article 34 prohibits is actually any national measure that discriminates against foreign products, other products from other member states. So, for example, is a measure which calls upon the citizens of a country to buy only its own products, buy Irish, for example, campaigns that call to buy Irish. Is that a discrimination against other, let's say if it's potatoes or whatever, other products from other member states? Is a campaign to stimulate consumption in a state with this kind of buy Irish campaigns? Is that discrimination against other foreign products? Yes. Yes, it is. This is already kind of crossing the threshold of simply putting labels or trying to express, making some claims about quality. This is a call to buy only national products, and it is clearly discriminatory because it to the contrary, then means that it is a call not to buy products from other member states. So that is clearly discrimination, and this would be a measure having an equivalent effect to a quota. So it also has the effect to restrict the amount of products that are coming into this country. What about alcoholic beverages, where, let's say, the Belgian state requires that every Scottish whiskey has to have a certificate of authenticity, but other products, other alcoholic beverages that the Belgians consume, I don't know, Belgian beer or whatever, do not need such a certificate of authenticity. Is requiring this kind of certificates of authenticity for certain drinks, but not for others, is that a discrimination that has a similar effect to a quota? It's a bit more borderline, but if it is clear that the measure, let's say the Belgian measure, aims only at foreign products and excludes all Belgian alcoholic beverages from such certificates, then you could say, well, this might also be discriminatory because de facto it only applies to Scottish whiskey, let's say, and not to Belgian beer. Or an equivalent to whiskey in Belgium. I mean, I don't know. I'm not a specialist in whiskey, so. But this could already be a bit more borderline. Now, our Italian pasta example is then, again, an even more difficult case because you don't have a clear direct discrimination. But it is also clear that by using this kind of signaling to consumers, you might potentially benefit local products as compared to foreign products. However, these are exactly the questions that came before the court around the 60s, 70s, and that were not clear-cut from the beginning. So there was really a choice to be made. Do we want to only apply these provisions of free movement of goods to clearly discriminatory measures that, you know, like in international trade, we'll look at, do they distinguish based on nationality or not? Or do we want to go beyond that and also remove other types of regulations that could hinder economic trade between the member states? And so here we are coming to a famous case, and again, it's about an alcoholic beverage. Cassis de Dijon is a liquor, a French liquor that people enjoy with a sparkling wine. It's a nice summer drink, and there was a case in which Germany had a law in place which said that fruit liquors must have at least 25% of alcohol. If they're weaker than that, they may not be called fruit liquors. So Cassis de Dijon could not be sold in Germany as a fruit liquor because Germany said our fruit liquors must be strong. They must have 25% alcohol content, at least. And so Rewe, a German supermarket company, brought a case before a German court, and the German court asked the question to the European Court of Justice, saying, well, Article 34, measures having measures having equivalent effect, do they actually cover this kind of differences in regulations? Because there is no discrimination on the face of it, because the German law applies to all products sold on the German market. It's not distinguishing between French and German and others. It applies to all liquors that are sold on the German market. And the German government said, well, we do this for consumer protection. It is important for our consumers when they drink fruit liquor that they know that this is a strong, that this has a content of 25%. Yeah, you're laughing. Why are you laughing? No, you're laughing. I'm also laughing. Why are we laughing about this? Yeah, well, it's kind of a bit of a ridiculous rule, to be honest, you could say. And the truth is that member states have plenty of somehow silly rules about these kind of things. Yeah, maybe it's not a real problem. I mean, I hear you. So I also have to smile when I think about this case. But okay, kind of jumping ahead to the analysis already. Let's stay with the case. So the litigation is brought. You are the judges, and you have to decide. You have a German rule about how much alcohol there must be in a fruit liquor. You have the German government says we need this for consumer protection. Otherwise, our people will get drunk and, you know, not realize. I don't know. I'm having difficulties following the reasoning. But something like that, they will have good lawyers who can argue this. And then you have Rewe who says, doesn't make any sense. Why wouldn't Cassis de Dijon be sold as a fruit liquor in Germany? Now you have to decide, which model do you apply? Host state, Germany's rules apply. And this is not discrimination because it doesn't distinguish between different origins of the fruit liquor. Home state, French rules apply. If the French call it a fruit liquor, it's a fruit liquor, and it can be sold. And harmonization, but at that time there were no harmonized rules on how much, on this kind of things. There were no EU-level rules on that, so we don't have harmonization. You have basically to decide between host state and home state. What do you say? I don't see the person who's talking. Oh, yeah, it's you. Okay. Home state, why?
Because they are not doing meaning to the French brand. They're just like, yeah, that's how it works here. Because if it was like intentionally trying to, oh, you just should drink jam products, it would be discriminatory. That's not.
You would say it's not convincing to have Germany keep this rule. It must be good enough. If it's good enough for the French, it should be good enough for the Germans. Is that what you're saying? Yeah, you say, you shrug your shoulders, it's a bit of a silly rule. What is this? Yeah, and I think maybe that's what the judges thought as well. In any case, it was decided in favor of the home state model, which means, and that is a very important rule in this case, and this was the Cassis de Dijon case, the European Court of Justice for the first time pronounced the so-called principle of mutual recognition. Okay, now I'll explain what that means in a moment. First, here is a definition of measures having equivalent effect. That legal definition applies until this day and is hugely important, and as an EU lawyer, you must know it. It was first developed in a different case in Dassonville a couple of years before the Cassis de Dijon case. And in that case, it said all trading rules enacted by member states which are capable of hindering directly or indirectly, actually or potentially, intra-community trade are to be considered as measures having equivalent effect. What is your reaction to this legal definition? What comes to mind when you read it? What strikes you about it? One thing that should strike you about it is this is extremely broad. If you take this definition, almost all national regulations, whatever the member states do, will fall under the scope of Article 34, which as a consequence means that member states must justify everything they do that has an impact on intra-community trade before the European Court of Justice. So, if we apply this rule, then yes, a German rule, even though it doesn't discriminate on the basis of origin of the product, a German rule on how much alcohol there must be in a fruit liquor, which is a rule about how this product is supposed to be produced, it can hinder intra-community trade. So it falls under Article 34. The scope of pre-movement rule is given. In addition to taking over and confirming this legal definition of a measure having equivalent effect, the Court of Justice has also pronounced the principle of mutual recognition. This basically means that a product legally, lawfully produced in one member state must be recognized as lawfully produced in another member state. Member states basically have to recognize each other's regulations. And as I said, there is a presumption of trust that member states can trust each other's regulatory system to catch the negative effects, the risks, and so on of products and goods and economic activities, and therefore we trust that we do this and we must accept these products on the domestic market. The only way for Germany to resist this would be to have a very, very good reason why it must nonetheless ban this fruit liquor on its market. So there is still the possibility to justify if there is a strong public interest. Germany argued consumer protection, but in this case the court said, sorry, I mean, doesn't really make much sense, not a very strong case of consumer protection. No, not justified. So we are back to the question of distributive consequences. And I mentioned, so this is, the Cassis-Dijon case is a very, very, very famous case because it announced this principle of mutual recognition, and this principle went on to apply in many other fields of EU law. And because it has basically assumed that we must trust each other's regulatory systems. Now, you can imagine that this, however, also creates a lot of difficulties. Perhaps not with fruit liquors, but with other things where we might be a bit more sensitive about trusting other member states to regulate the same way we would like things to be regulated. By we mean the domestic market. So we still have to keep in mind these kind of implications. And to make this clear, I want to give you another example. And that is a more recent example. The city of Amsterdam, I think it happened only this year, has issued a ban on advertising for meat and for fossil fuels, so things like flying. So a ban on advertising for, cheap flights or meat products. The reason behind it being that they want to limit this kind of measures that can, again, influence consumer behavior and, motivate consumers to fly more and to eat more meat products. And that is, as you know, one of the drivers of CO2 emissions and, one of our consumption is one of the drivers of climate change. And so that is an environmental measure, yeah? So let's think a little bit in this scheme of things of Article 34. First question, is there a cross-border element? Is there trade between member states? Well, yes, you can imagine Amsterdam is a big international city. There might be some advertisers here or some traders of meat who are coming from other member states. So let's just assume there likely is to be a cross-border element here. So Article 34 applies to this situation. And by the way, this case concerns meat and fossil fuel advertising. When it comes to advertising as a service, we are in the realm of a different freedom, the freedom of services. We are not dealing with it today, so we will only focus on, let's say, the element of this case that concerns goods, for example, advertising on meat products. So we are only focusing, there are two things here, there's services and goods. We are focusing only on the free movement of goods, and we are leaving services aside. So, okay. Is meat, let's stick with the meat example, is meat a good? Obviously, yes. Are we dealing with a quantitative restriction? Is this a quota on how much meat can be sold? No, it's not. Is this a measure having equivalent effect to a quantitative restriction? Okay, we take out the Dassonville formula. Any trading rule that can hinder inter-community trade potentially or actually now or in the future. Does banning advertising for meat products fall under a trading measure that can hinder inter-community trade? Imagine you are working in this sector, and you are a meat distributor or a supermarket. You want to advertise your products. Would you argue that this hinders your inter-community trade? You're a Spanish. You are importing jamon into the city of Amsterdam. Under the Dassonville formula, it will fall under it. It's very, very broad, yes. Yes, under the Dassonville and Cassis-Dijon formula, it falls under Article 34, which would mean that the city of Amsterdam would have to justify this measure of banning advertising on meat products under EU law. Is this as silly as the fruit liquor example? A little less silly now, no? Is that a legitimate outcome? So would that be a legitimate outcome to say, you know, even environmental measures, which are not banning meat products, by the way, but which are just trying to curb advertising and thereby indirectly sort of stop these effects on our consumer behavior? Is that still something that we have to justify under EU law, or is this going too far? The problem with the Dassonville-Cassis de Dijon definition of a measure having equivalent effect is that it does go pretty far, and it basically catches any economic activity within a member state. And the question is, why should this be a matter for EU law and not for national law? And now, there was no case on, this is a recent case of the Amsterdam ban. I just took it as an example to do the legal analysis. There is no case law on that. But we do have all the case law which came after Cassis de Dijon and which dealt with this similar question and similar problems. So, for example, in the Torfen case, there was an Irish law prohibiting retail shops from selling on Sundays. This was, again, not a discriminatory measure. It was just a national regulation. The Irish wanted to have these kind of rules on when retail shops should be open. Why should they not be able to do that? Why do they have to justify that under EU law? Under the Dassonville and Cassis de Dijon formula, it would fall under Article 34 and would be a measure that would, in principle, be prohibited. When this case was decided, it created a lot of upset. And people started saying, well, this formula is clearly too broad, and it allows, in consequence, EU law to intervene in every matter of national law. And this may not be a good outcome. Because the purpose of EU law is to regulate cross-border trade, not to restrict any type of regulations that touch upon market activities. Different purpose. So, and that is why the last thing that I would like to tell you about today is that after this case law, this problematic case law that defined the scope of Article 34 so broadly, we got another famous case, and this is something that you must also know. So you must know Dassonville, Cassis de Dijon, Keck. This is kind of the line of case law that you will also practice in the tutorial. And in Keck, the court decided to roll back. It acknowledged that to some extent, this definition of MEE, the measures having equivalent effect, went a bit too far. So it introduced a new distinction, saying, okay, for national measures that regulate product requirements, such as regulating how much alcohol content there must be in a beverage, those so-called product-bound measures, these, when member states regulate these, they do fall under Article 34. However, if it's just about the way of how a product is sold or how it is advertised, that is a selling arrangement, and here it's up to the member states to decide how they want to go about this. So introduce this distinction between a selling arrangement and a product-based, a product-bound measure. For a selling arrangement, such as an advertising ban, if it is non-discriminatory, it doesn't fall under Article 34, and it doesn't have to be justified. If it is discriminatory, if it does distinguish on the basis of nationality, then it still falls under Article 34. And so on that account, the conclusion for the Amsterdam example would be that it is a selling arrangement. It falls under the Keck jurisprudence, and therefore, because we don't have more information, but let's assume it's not discriminatory. If so, it doesn't fall under 34, and it doesn't have to be justified. Okay, so this is another legal step, another legal technicality in the evolution of the case law of the Court of Justice on the free movement of goods. And essentially what you see here in all these legal technical steps is the struggle over the question of how wide is EU law, how broad is its scope, how much does it actually dictate to member states in terms of what they're allowed and not allowed to do when they regulate their markets. And of course, these questions have very sensitive implications for sovereignty and for national rights to regulate. And this is why Brexit, benefited a lot from these kind of arguments. The parties who were in favor of Brexit, they said the EU is, regulating the size of cucumbers and is intervening in all sorts of matters. Why do they do that? It's wrong, and so on. So it's quite sensitive politically, although it is legally technical, I admit. But this is what I wanted to leave you with. Now, we don't have a lot of time left, but I think in the tutorials you will also practice this step. Now, after you've done all the analysis of does Article 34 apply? Do we have a measure of equivalent effect? Once you've done this, the last step, as I said, would be to look at justifications. Justifications are laid down in Article 36, which says that if member states restrict free movement, they may do so if they justify their measures with certain public reasons, certain public goods. And the reasons are mentioned here. So there are certain grounds of justifications which are accepted. Member states, of course, have to provide some evidence that they, for instance, do want to protect public policy or health or other things. Now, as you can see in this article, environmental protection is not mentioned. So if we think back about the Amsterdam advertising ban, could it be justified? Article 36 doesn't say anything about environmental protection being a legitimate reason to restrict free movement of goods. The answer is yes, but not on the basis of Article 36, but on the basis of case law that started with Cassis de Dijon and which followed, in which the court said for measures that do not discriminate, but still fall under Article 34, so measures having equivalent effect that still are caught by free movement of goods, they can be justified if they are non-discriminatory on the basis of other so-called mandatory requirements. And what these are is defined in the case law, and you basically sort of have to know what the court defined as such a requirement. And here you find consumer protection and environmental protection. So the takeaway for you is, once you have a situation where you have to apply Article 34 as the prohibition on quotas and measures having equivalent effect, you have to check whether the scope, whether the article applies, whether you're dealing with goods, whether you are dealing with trade between member states. Then you have to decide, now, is this a restriction that falls under Article 34? Is this a quota or is this an MEE? You check the definition that I provided you with, you decide, and then you conclude, yes, there is a violation of Article 34. Then you go, is it justified? Article 36 for all national restrictions. And if you are dealing with a non-discriminatory restriction, you then move on to the so-called mandatory requirements, and you go from here. How justification works in detail, you can discuss that in the tutorials. Very important is the principle of proportionality. And you can, I hope you get to discuss a bit how this works, because it is something also that you need to practice. It's a tool of legal reasoning that proceeds in different stages, where you look at, now, is the goal, in this case, does Amsterdam, the city of Amsterdam, does it pursue a legitimate goal? Environmental protection, yes, it's legitimate. It's a mandatory requirement. Is that measure to ban advertising necessary to achieve environmental protection. Now here you can argue, you could say, well, it's just a ban on advertising. How will it curb CO2 emissions? You could say, well, because it might have effects on consumer behavior and it might lead to less consumption. There could be an effect, so it would be a necessary measure. And then in the end, there is a step of balancing where you say, okay, now we balance the importance of environmental protection versus the economic interest of having a free movement of meat products in the EU. This is what judges do. They balance these kind of concerns against each other. And then in the end, you have a conclusion which says there was a restriction, there was a violation of Article 34, but it was justified because it was proportionate. Okay. Do you have any questions on Article 34, 36, on the cases we discussed? Again, the Amsterdam advertising case is a hypothetical. There was no judgment on that. I used it just to illustrate and to make the point that in some cases, a broad definition made sense, like in the Cassis de Dijon case, but in other cases, it can be problematic, which is why, through CAC, the court tried to narrow down the scope of Article 34 again. All right, if you have questions, you can come to me, and otherwise, next week, you're going to proceed with Matteo Vermeglia and look at the external relations of the EU, and then followed by a lecture on Brexit. And I wish you a lot of fun with this course. And maybe I'll see you around at the end again. Okay.
Question regarding if the EU has actually some legal basis to implement protectionist measures, because like what we see and what you say, it's all these measures are all about to promote this neoliberal idea of Europe and to promote commerce. However, are there some legal procedures or bases that the European Union can use to put like protectionist measures?
Well, inside the EU or vis-à-vis the rest of the world?
Inside the EU.
Oh, I have to collect my things. I'll come down.